Assistant Professor of Law from Vignan Institute of Law. I thank the management of Dharmapeetam for giving this opportunity. So today the topic we are going to discuss is the mechanism and enforcement of human rights, especially in India. So we already know what are human rights and Universal Declaration of Human Rights. The main focus of today's lecture is with regarding to how effectively these human rights will work in India. So this is our lecture. We will proceed with this. So, how protection of human rights came into force? So, a brief introduction with regarding to human rights. We all know that previously, before Second World War, there has been a lot of even in World War One and in World War Two, a lot of genocide happened. Even Nazis killed many Jews people, etc. Germans, Hitler, many things happened. So then the world countries thought that why can't we have some human rights? Even this human rights concept not only originated in the modern world, it will be dated back to even the ancient civilization as well. For example, in medieval era, we have a Babylonian king Hammurabi. He is the one first time who gave in brief introduction to rights of people. Second is nothing but the Magna Carta. We all know that the Magna Carta, it is one of the fundamental principles with regarding to rights of people and what are the taxes regarding etc. So apart from this, we have French Declaration of Rights. French Declaration of Rights also played a very most important role with regarding to origin of fundamental rights or human rights. Initially, during the medieval and ancient days, there is no a concept of human rights. But the thing is, the origin of human rights can be traced back to natural law. Later, the natural law became into origin of human rights. So this is with regarding that. So once after the Second World War II, the formation of UNO and the UNO Charter. After this UNO Charter, then the responsibility was given to ECOSOC, Economic and Social Council. Then the Economic and Social Council, then they decided to come up with a declaration that is called Universal Declaration of Human Rights 1948. So later, as an add-on to this, the International Covenant on Civil and Political Rights, International Covenant on Economic, Social and Cultural Rights, all this put together we can be called as a Bills of Rights. All this put together we can call as a human rights. So this is in brief introduction with regarding to what are human rights, etc. So coming to this today's lecture, that is enforcement mechanism in India. We all know what are human rights and in brief detail about human rights in the world and in India. But the thing is, not only the Universal Declaration of Human Rights, but also the ICCPR, that is International Covenant on Civil and Political Rights. And next we have that is International Covenant on Economic, Social and Cultural Rights. And even we have CEDAW Convention. CEDAW Convention is nothing but elimination of all forms of discrimination against women and Convention on the Rights of Child. All this put together we can combinedly call, these are the international different declarations and conventions with regarding to human rights that are available to all the member countries. So coming to India, in India we have National Human Rights Commission. How it came into force in India? So if you see, there is a concept that is called Paris Principles. So once the UDHR declaration happened, later after UDHR declaration we have a series of conventions. Then every time when the world countries they are discussing, a uniformity should be there for every country, a mechanism process to protect the human rights of people. Then in Paris Convention, all the member countries they thought that we must have a common set of rules where all the countries can establish a human rights institution. So basing on this Paris Principles, India is a signatory to it, and India is a signatory to all the conventions like UDHR, ICCPR, and even also the Convention against discrimination against women. So India as a part of it and also party to Paris Principles, India later adopted a historical resolution. Initially we can say it is an ordinance. Ordinance was promulgated by the President of India. Later it was replaced with a law that is called the Protection of Human Rights Act 1993. So this is the act. We have 7 chapters in it. The first chapter generally dealing with National Human Rights Commission. So that is the main apex body in India which protects the human rights of people. So after that, second chapter we have functions, powers of commission. Not only establishing the commission, but also entrusting the commission with multiple powers and functions. So which the commission can perform without any bias, and also the commission can investigate the matter. So this all has been mentioned in the second chapter, that is functions, powers of the commission. Next, apart from that, we have also the concept that is called procedure. What is the procedure for investigating the disputes with regarding to human rights, and how the recommendations can be given by National Human Rights Commission to Parliament, even government, and how all these recommendations has to be placed before Parliament. So this is another chapter. And apart from that, we have finances, accounts, audits. Apart from this, we also have State Human Rights Commission. Not only National Human Rights Commission, but also we have State Human Rights Commissions. As we all know that there is a legislative distributive power between center and state, that we have three lists, that is union list, state list and concurrent list. The state list subjects that are comes under the purview of State Human Rights Commission. So apart from that, we also have concept of Human Rights Code, that anyway we will be discussing in the coming slides or coming session, in the same session. So first we will be going with what is the Protection of Human Rights Act. Generally we have to come to know about what is the act. The Act of Protection of Human Rights 1993. So the act came into force from September 28, 1993, and it applies to whole of India. And one more thing we have to remember, that the jurisdiction of National Human Rights Commission, that is applicable to only the legislative matters of available in central list and concurrent list. That we should be very careful while writing an answer, that the jurisdiction will be applicable only for the matters enlisted in union list and concurrent list. So what are the different bodies that has been established under the Protection of Human Rights Act? The first apex body, as we already discussed, that is National Human Rights Commission. Second, that is State Human Rights Commission. And third, that is Human Rights Courts. So one of the important thing that we have to discuss, that is what is the definition of human right. Initially, whether it is in UDHR or in ICCPR or even other conventions, they didn't exactly define what do you mean by human rights. But the thing is, in India, that is the Protection of Human Rights Act 1993, they have defined, but I can't say it is an exhaustive definition, but it is a very narrow definition. They are saying that human rights means rights relating to life, liberty, equality, dignity. So we have fundamental rights, that is in part 3 of Indian Constitution. Fundamental rights are very exhaustive in nature. Whatever the right, it will comes under the purview of Article 21. There are many multitude facets of Article 21. But coming to this act, maybe intentionally or unintentionally, we don't know, but the government has defined in a precise way what is the meaning of human rights. So they're clearly saying that rights with regarding to only 4, that is life, liberty, equality and dignity of individual. So that means as much as possible the government tried to narrow the definition of human rights. So this is the definition which has been mentioned under section 2D of Protection of Human Rights Act 1993. So coming to the apex body, that is National Human Rights Commission. So this I am teaching along with the recent amendment of 2019. So this is the body, as you all know, this is the apex body with regarding to human rights and protection of human rights in India. It was established under the 1993 Act. So we should always differentiate between what is statutory body and what is constitutional body. For example, if you take a body which mentioned in Indian Constitution, then it is called a constitutional body. But coming to a body which was established by the authority of some act, then it can be called as statutory body. And hence the Human Rights Commission, it is not at all a constitutional body, but it is a statutory body. So this was established under the act that is called Protection of Human Rights Act 1993. So generally, the purpose of establishment of this apex body, human rights body, is it is like a watchdog to protect the human rights of people. Then you might get a question like, already we have fundamental rights. These fundamental rights are nothing but, if you see the timeline, the fundamental rights in India, they came into force from 1950, that is from our Republic Day, and at the even the Constitution of India, the makers of Indian Constitution, they have started working on Indian Constitution, that is from 1946 and 47. Even at the same timeline, the work for uh, human rights also has been started, declaration of UDHR. So that means both the declaration of human rights as well as the fundamental rights framing has been happened within a same timeline. So if you see, the UDHR came into force in 1948 and the fundamental rights in Indian Constitution came into force in 1950. That means definitely we can say the impact of UDHR is on our Indian fundamental rights. So most of the uh, articles which are in UDHR, that is Universal Declaration of Human Rights, those are part and parcel of, I can't say everything, but many of them are part and parcel of 19 our fundamental rights, which has been enshrined in our Indian Constitution in under Part 3. So if you see, these are the objectives of commission. The first object is to enhancing the human rights framework to protect the human rights of people, and apart from that, the main other objectives of commission is also to inquire the matters with regarding to human rights in India and investigate the matters with regarding to human rights in India. So now we will say composition of National Human Rights Commission of India. So there is a significant change. A change has been happened, that is by way of 2019 Amendment Act by 2019. So generally it is a multi-member body. The NHRC, National Human Rights Commission, will be headed by a chairman. The qualification for being a chairman of National Human Rights Commission is he must be a person retired Chief Justice of India or a judge of Supreme Court. Initially, this part is not there, that is judge of Supreme Court of India. However, it was added by amendment in 2019. So there are 5 full-time members and 7 deemed members. That is, by virtue of their position, 7 already the members of different commissions. For example, if you say National Commission on Women is there, like that we have National Commission for Backward Classes, National Commission for, we have SCs, National Commission for STs, as well as we have National Commission for Backward Classes, and also Commission to look after the child and disabled person. So regarding all these things, all the 7 commissioners of statutory bodies as well as constitutional bodies, they have been given a deemed membership in NHRC. That means NHRC doesn't have only appointed members and also nominated members, but at the same time NHRC has the members from different commissions at the national level. So coming to the other members, generally chairman will be there and other 5 members will be there, plus there will be 7 deemed members. So coming to this 5 members, out of this 5 members, apart from chairman, 1 person should be a retired judge of Supreme Court or serving judge of Supreme Court. So out of 5 members, 1 at any cost the chairman should be from judiciary and another member should also be from judiciary, that he might be either serving member or retired member of Supreme Court. So apart from that, the rest 3 members, they should be the members who has a sufficient knowledge on human rights, they are working for the society and they are considerably working in the area of human rights, and out of that 3, 1 should be women. So this is the composition of National Human Rights Commission. So one of the greatest thing is, they not only, the Human Rights Commission consists of not only the members nominated or elected by the government, but also all the commissions, important commissions, their commissioners also became part and parcel of this Human Rights Commission. So one of the most important thing, that is appointment of members, that is chairman and members. So one thing I would like to say, there is an organization called Ganhari, a global alliance for accrediting of national human rights. It's an international body. Recently, it's a recent issue in 2024. That body clearly said that that body main function is to accredit the national commissions. For example, in India we have National Human Rights Commission. Like that, in every country there will be one human rights body. The main purpose of this Ganhari body is to give accreditation, status of A grade, like that. So they clearly said that this year we are going to stop the accreditation for National Human Rights Commission of India. The reason is they are clearly saying that there is an excessive political interference in appointment of members of National Human Rights Commission. So that is one of the main reason the accreditation for India for the year of 2024 and for the 3 years has been stalled by Ganhari. So coming to the appointment procedure, as we said that there will be 6 members including chairman and 5 other members. This is the procedure will be followed for appointment of these members. The procedure is generally there will be a selecting committee. Who will be part of this selecting committee? Always the Prime Minister is one member. Next we have Speaker of Lok Sabha, Deputy Chairman of Rajya Sabha. Always remember that not a Chairman of Rajya Sabha. Here it is the Deputy Chairman of Rajya Sabha and Leader of Opposition Party and Central Home Minister. Apart from these 5 members, if you see the 5 members, Prime Minister, Lok Sabha Speaker, Opposition Leader of both houses, that is Lok Sabha and Rajya Sabha, and Deputy Chairman of Rajya Sabha, Central Home Minister. Apart from this, a Supreme Court Judge, the Chief Justice of India, or any other person nominated by Supreme Court Chief Justice of India, all these 7 members put together, they will decide on the names of members of NHRC. That means NHRC members are not appointed only by the whims and fancies of the central government, but they are appointed by a committee. That committee consists of ruling party members, opposition members, and even the Supreme Court, Chief Justice or any Supreme Court judge. All this combinedly with a consensus and with a majority, they will appoint the members of National Human Rights Commission. So this is the procedure for appointment of members of National Human Rights Commission. So regarding tenure, the chairman or other members, they will hold the office for 3 years or 70 years, which is earlier. We have to remember that which is earlier means, for example, if a person has been appointed as a member of NHRC, then by 68 he will complete the 3 years tenure. Then he can't say that I can stay in the office till the age of 70. But if a person appointed at the age of 68, then the 3 years clause will not applicable. Then at any cost he should be retired at age of 70. So that means either he should have a tenure of 3 years or 70 years, whichever is earlier. So initially, before 2019 Amendment Act, the members has an option for reappointment. But the government in 2019, they made the amendment and they said that once you are a member of NHRC, again you can't become the member of NHRC. That means once in a lifetime that you are appointed, that's fine. This is the last time. Next time you are not eligible for reappointment. So this is the major change brought under 2019 Amendment Act. So another thing, as we discussed about appointment, there is also a provision for removal. So however, the process to remove the judges of High Court, Supreme Court is different, but here they are following a different reasons. They can be removed by the president on after the inquiry conducted by a Supreme Court judge. After the opinion and inquiry investigation, they will give the recommendation to President of India. But what are the grounds of removal? On what purpose we can remove the members of NHRC? That is, the first one is insolvency. As everybody know that even in contracts, not only in Indian Contract Act, but also everywhere, if a member who has been adjudged insolvent, then he will be disqualified to become member of any constitutional body or any statutory body, and even from all the offices. Second, infirmity, whether it is a physical infirmity or a mental infirmity. If he became insane, then also he will be disqualified and he will be recommended for removal, and the president will remove from the office. That is another ground. Third is imprisonment. This is one of the important thing. If they have been imprisoned, then they will be disqualified. But if you see, for parliamentarians, they will be disqualified if they have been convicted. But as per Representation of Peoples Act 1951, they will be disqualified. I mean the parliamentarians, not NHRC member, just I am comparing for your knowledge sake. So parliamentarian can only be disqualified if they are convicted for 2 years or more as per section 8 of Representation of Peoples Act 1951. But coming to this removal of NHRC member, they didn't even mention whether a conviction period of 2 years, 5 years or nothing. But they clearly said that if he is convicted and sentenced to imprisonment for offense, then he will be disqualified. But here one more thing is, if he is convicted but he is not imprisoned, or he may be fined, just a fine of 10,000 might be levied, etc., then in that case the NHRC member won't be disqualified. Next, any paid employment. So during the tenure of this 3 years or 70 years, whichever is earlier, they should not indulge in any other private employment. Okay, if they indulge in any private employment, or they are just want to get any tenders of government, or through any other third party, if they try to do so, then if it is proved, then they will be recommended for removal from the office. And last one is unsound mind. So these are the different criteria that are there for the removal or reasons for removal of the members of NHRC. So the most important thing, functions of Human Rights Commission. So as it is apex body, it was entrusted with many functions, but we will look after each and every function and we will do some critical analysis whether it will be effective or not. So the first we can see is investigating the violations of human rights. So as a apex body of human rights, it always has every power to investigate if there is any human rights violation. And one of the most important thing is it can investigate on sumo motu case basis. That means without even any application or anything on sumo motu, they can take up the case. That is one of the important function of NHRC, powers and functions of NHRC. And one more thing you all have to remember at any cost, that is, for example, today one human rights infringement happened, or if somebody committed suicide, maybe if complaint has been lodged with NHRC, they'll investigate. Or a group of people's human rights has been violated, if you lodge a complaint, Human Rights Commission will be investigating the matter. But the thing is, there is a limitation period. Many don't know that what is the limitation period with coming to human rights complaint, but the limitation period is 1 year. If any incident happened before 1 year, then it cannot be, the NHRC cannot investigate the matter. So this is regarding to limitation period for NHRC. So not only investigating the matters, but also it has every power to see whether the jails are in proper condition, even not only jails, detention centers, even child rehabilitation centers, everything. So they will check everything and they can go without any prior permission of any other government or any other body. So these are all the different powers of NHRC. So next thing is, even they can support NGOs also. Those NGOs who are working for the human rights, they can support them. Not only that, apart from that, they can also spread awareness. Recently, NHRC is encouraging even the legal education institutions as well. They are providing internships and they are providing funds for projects. For example, if there is any human rights violation, if you want to do some research on it, even the NHRC is providing as a fund to do research. So these are all the different powers and functions of NHRC. So already we discussed everything. Not only they have investigating powers and everything, NHRC also has a power of civil court. They can investigate, they can summon person, and they can also collect the evidence, and they can submit the recommendation to government. So all these things can be done by National Human Rights Commission. And NHRC will have a separate investigating staff. So as like it's an independent body, they can recruit their own investigating staff. Apart from what the judicial investigation happening, it can also investigate and can submit the report to government. So the main question is, what action can be taken after the completion of investigation. So many will ask, many will say that NHRC has many powers and functions, but the thing is, it can only recommend the government, but it cannot order the government, or it cannot summon the government, or it cannot authoritatively tell the government. The only thing it can do is it can give recommendations. For example, for many victims, NHRC played a crucial role for payment of compensation. But the thing is, they can't pay from their own. Only NHRC they can do is they can ask the government to pay the requisite compensation. So this is the most important thing. So by this we can come to know whether it has a full-fledged powers or the powers for namesake. So if you see, a investigation has been done by NHRC. If in that investigation, if they come to know that some lapses happened, but they can't order for any punishment and they can't order for any payment of compensation, what they can do is they can recommend the government, this happened, this is the incident, there is some lapse. So the government, they will ask the government, direct the government, recommend the government to pay the compensation to victims. And whatever the NHRC will be transferred to government, it will be the way of recommendations, but not by way of any other order or authority. So as we see, commission's role, mostly the commission's role is recommendatory in nature, and it don't have any power to order for any punishment or imprisonment, etc. And most of the recommendations are non-binding in nature. It's not authoritative recommendations, they are just recommendations. It is up to the government whether to follow the recommendations or not to follow the recommendations. But the thing is, the government also, they have to submit they have to place whether they are complied with the recommendations or not in parliament. So that means some sort of checks and balances are there. For example, if NHRC gave 120 recommendations in this year, then the central government, they have to place all these recommendations before the parliament by saying how many of them have been complained, how many they unable to comply, and what are the reasons for not complying with the recommendations of NHRC. That means some sort of checks and balances are there. But however, we can say NHRC can only recommend the government, that too it's not binding on the government. But still, as we all know that these days media trial, everything has been there, influence of media also there. If NHRC gives any report, recommendation, if government willfully disobeys that, then the censor by media will also be there on government. So most of the recommendations which are feasible will be accepted by government. So these are the different clippings from the news that I have attached here for the sake of your understanding. Recently, you all might know that a suicide of Nepali student in Orissa, some college in Orissa, NHRC on sumoto basis, it took the case. So that means it is saying that wherever some lapses happen or infringement of human rights are there, NHRC is actively, they themselves, they are taking the cases, they are investigating, and they are recommending what is the cause of violation of human rights and what can be done, whether compensation has to be paid or whether so and so persons are culprits, whether they can be punished. So that means NHRC, though it's a recommendatory body, but still as it is an apex body for human rights, they are acting, not they are just sitting and directing the government. But these are the only recent incidents in 2025. Few of them I have attached here, even in Mushirabad, etc. And madrasas also, recently they have went to all different madrasas that are in Uttar Pradesh, and many orphanages they are visiting, and they come to know in few places child trafficking is also happening. So not only just visiting jails, but also they are every nook and corner of society where there is a chance for human rights violation. These days actively they are going and they are reporting it to the government, and also they are investigating. So these are the different recent incidents which I posted here for the sake of, you may think that NHRC is a paper tiger on paper only, on act, but it is acting and it is giving recommendations. So this is all about National Human Rights Commission. Next, that is State Human Rights Commission. So the State Human Rights Commission, as we said that the Protection of Human Rights Act 1993, it gave for three bodies. The first body is NHRC, second establishment of second body, that is called State Human Rights Commission, and the third body is Human Rights Courts. So as we discussed about National Human Rights Commission, then State Human Rights Commission. So as we all know that India is a federal country, but many will say it's a quasi-federal. But my opinion is a federal with unique features, as there is a distribution of power between center and state, as there is a legislative distribution of power, like we have central list, state list, and concurrent list. Like as center has power to monitor human rights violation on the matters enumerated in the central list and concurrent list, like the same way the state government also, they have established a body that is called State Human Rights Commission, which can inquire into the matters with regarding to violation of human rights, that especially with regard to the matters concerning in state list and concurrent list. So the jurisdiction of State Human Rights Commission already we discussed. It can inquire into the matters which fall under the legislative competency of the state. But the thing is, if already NHRC is investigating that matter because of its amplitude or very big issue, then State Human Rights Commission cannot intervene. So this is one of the limitation on State Human Rights Commission. So this is with regarding to composition of State Human Rights Commission. There will be a chairman and two other members. As we same like National Human Rights Commission, as we discussed for National Human Rights Commission, there it is a 5-member body, but coming to state, it is a 3-member body. So first one is the chairman. The chairman is, he will be appointed if he is a retired Chief Justice of High Court or a retired or serving judge of a High Court, and the second member should also be a judiciary member. So that means out of 3 members, 2 will be a judicial appointed members, and second member, he should be also from judicial fraternity. That means he might be a judge of a High Court, retired judge of a High Court, or even a retired district judge or a district judge with minimum of 7 years of being a experience of district judge. So this is about the composition of second member. And third member, he might be a member who has a specific knowledge on NGO, on human rights. He might be a person from NGO, or he might be an advocate, or any person who is working in the area of human rights. So this is the composition of State Human Rights Commission. Coming to the committee which will appoint the members. So as we discussed earlier, for National Human Rights Commission, there is a committee that will appoint the members. Like as we discussed, the members will be from, that is ruling party, and also from leader of opposition, Home Minister, Prime Minister, and also Supreme Court Chief Justice. Like the same way, they have meant also for the State Human Rights Commissions. For example, if you see, the Chief Minister will be a part of a committee or a committee member who will decide on the members of State Human Rights Commission. The second will be the Home Minister of the state, and third, chairman, Speaker of Assembly and chairman. If there is some states in India, they have council also, the chairman of the council, and opposition leaders from both the houses. If it is a one house, only from one house, and a member of High Court. So all these persons, generally, they will decide on the appointment of members of State Human Rights Commission. And same criteria, tenure is 3 years, and I think it is 65 years, and they are unable, they cannot be reappointed. Once they are a member of State Human Rights Commission, they cannot be reappointed. Might be they can be appointed as a National Human Rights Commission member, but they cannot be appointed as a State Human Rights Commission member. And the interesting thing is, these members are appointed by governor. As we discussed earlier, the National Human Rights Commission members are appointed by President of India, but the state commission members are appointed by governor. But one of the biggest thing that you have to remember is, but removed by president only. That is, appointing authority is governor, but coming to their removal, it can only be done by President of India, but not by governor of any state. So basing on the same criteria that earlier we have discussed, the same criteria, if they are insolvent, if they are engaged in paid employment, or if they are unsound mind, are imprisoned or convicted and imprisoned for any offense, then on these grounds they will be removed by President of India, not by governor. Appointing authority will be governor, but they can only be removed by President of India. Coming to functions of Human Rights Commission or State Human Rights Commission, similar to the powers and functions of National Human Rights Commission, they can investigate, they have the power of civil court, and they can like do awareness camps. Apart from that, they can visit the jails and they can work on what are the conditions of jails in India in that particular state, and they can give recommendations to state government. As like same like National Human Rights Commission, state body also will give recommendations only. They don't have any authority, or they can't order for penal like punishment. They can't order that so and so person can be prosecuted and can be punished for 2 years of imprisonment. That cannot be done by State Human Rights Commission as well as National Human Rights Commission. But the thing is, they can only thing is they can recommend the government. Same like NHRC, what are the recommendations by State Human Rights Commission that has been given to state government? It has to be placed before the assembly. So before concluding of that year, the government has to say how many recommendations they have been received and how many they have complied and how many they didn't comply and what are the reasons for not complying. For example, financial constraint, or example, if state commission orders 1 crore compensation and the state government is unable to comply with that order, then they have to write because of financial constraint we are unable to comply. Or if state human rights commission, if they says that so and so person might be the reason for all this violation of human rights, then if they are unable to comply, they have to write because already the matter in high court, etc. So that means what I am trying to say is, maybe the recommendations of NHRC and state commissions, they are recommendatory in nature, but some sort of checks and balances are there because their recommendations and which are complied, which are unable to be complied, that has to be placed in assembly and parliament respectively. So coming to the commission powers, they have judicial powers. They can get the information from any body within the state and they can give recommendations, etc. As we discussed, they have very limited jurisdiction. Most of the jurisdiction is not binding in nature. They can give not binding recommendations as well, and no punishment power. So this is with regarding to State Human Rights Commission. And then Protection of Human Rights Act 1993, apart from that, NHRC and also State Human Rights Commission, they recommended to establish a human rights courts. So what are human rights courts? So as per section 30 of Protection of Human Rights Act, they said that in every district, on equal with sessions court, a human rights court has to be constituted. But the thing is, they have used the word may. As a legal and judicial person, as a student of law, we already know what exactly it does means by using the word may or shall. So the word used in section 30 is may. So it clearly says that it is not mandatory. If it is feasible, the state governments will establish with the consent of High Court. If it is not feasible, they may or may not comply with this provision. So by this, we can say that hardly 2 states they have established the human rights courts in India. One is Tamil Nadu and another, I think, Assam. I think exactly I didn't remember. But the thing is, they are not at all functional. So all the states, even Andhra Pradesh, they notified that they also want to constitute the human rights courts. But the thing is, except 2 states, no other states in India, they have constituted this human rights courts. Even though they have constituted, most of them are not functional. So this is with regarding to human rights courts. So that means, as per the Act, we have 3 bodies: NHRC, State Human Rights Commission, as well as we have human rights courts. Out of this, only the national and state level bodies are functional. But at the district level, what are the recommendations? What are the provisions that has been kept under NHRC Act 1993 was left at the discretion of government. So because of that living discretionary power, most of the governments are not complied with this. So another topic from your syllabus, this is not a part of NHRC, but this is National Commission for Backward Classes. So one interesting thing is, National Commission for Backward Classes, initially it is a statutory body. So before that, it worked if any grievance is there for members of backward classes or any violation of their rights, it is generally under the control of, under the purview of National Commission for Scheduled Caste. So there is no separate entity was there for National Commission of Backward Classes. However, later in 1990s, they made it a separate body in 1993. But however, in 2018, it has been given constitutional status. So that means from statutory body to it has been upgraded as constitutional body. There are many commissions like SC Commission, ST Commission, National Commission for STs and for children, physically disabled and women, minorities, etc. But the thing is, only 3 commissions they have constitutional status. For example, National Commission of STs, this is the oldest commission of the 3. It enjoys the constitutional status because the provisions has been enumerated in Indian Constitution. So later the second body is National Commission for uh, SCs, and recently in 2018 the government with 102nd Constitutional Amendment Act, they have upgraded the status of National Commission for Backward Classes into a constitutional body. So now this body enjoys the constitutional status. So the concerning article for this is Article 338B and Article 342A. So what this body will do generally, they will investigate if there is any issue or any violation of rights of backward classes. They will investigate and they will recommend the President of India regarding inclusion and exclusion of members, any community in the category of OBC. OBC is for central, so that's why they will recommend the president. So this is the criteria of this particular community. Better if you include in OBC status. So all this will be done by National Commission for Backward Classes, and we all know that income limit is there for backward classes regarding creamy layer. If a person whose parents are group 1 officers or group 2 and earning more than of 8 lakhs, they don't get reservation of OBC. That ceiling can also be recommended by National Commission of Backward Classes. So this is all about a National Commission for Backward Classes. It has also same like a power like a civil court. So this is in brief with regarding to this body. And coming back to human rights, you all may get a doubt, as we have National Commission for Human Rights, State Commission for Human Rights. The thing is how it can be enforced. This is one of the question that many students will have while they are studying with this topic, that is human rights and enforceability in India. So that we will try to answer here. So as I said earlier, the definition, that is section 2D of human right, Protection of Human Rights Act 1993, Indian Act, it clearly says that human rights with regarding to, it clearly says that rights with regarding to life, liberty, equality and life, liberty, equality. So regarding this, they are clearly saying that we have multiple, as we know, we have 6 fundamental rights. In that 6 we have multiple rights. So, but coming to this human rights, they have decreased, narrowed the scope of enforceability of human rights. So they have confined the human rights. So how human rights are part of fundamental rights? Like I said earlier, we have International Covenant on Civil and Political Rights and Human Rights, UDHR. These combinedly, this part has been included in Part 3 of Indian Constitution, that is fundamental rights. And we have another covenant, that is International Covenant on Economic, Social and Cultural Rights. These provisions has been included in the directive principles of our state policy. So intentionally, the framers of Indian Constitution included DPSPs as unenforceable. Why? Because the viability matters. Because the government might have funds or may not have funds to enforce its directive principles of state policy. So that means the framers of Indian Constitution consciously, they have included the provisions of human rights in Indian Constitution. So regarding the enforceability, as I said earlier, only 4 categories of rights has been selected by the lawmakers. They have included in 1993 Act. The 4 are life, liberty, equality and dignity. So, for example, there are many rights which are not included in 1993 Act, like Article 25, and we have even you can see the prohibition of child labor and rights of minorities, Article 29 and 30. So, these are not, they are excluded from the purview of 1993 Protection of Human Rights Act. So, if you see, there are how we can divide, like comparison of human rights with fundamental rights, how we can divide, we can divide it into two. One is enumerated rights, another is unenumerated rights. So what are enumerated fundamental rights? For example, those provisions which are part of UDHR, International Covenant on Civil and Political Rights, and International Covenant on Economic, Social, and Cultural Rights, if they are directly part and parcel of fundamental rights, then those rights can be called as enumerated fundamental rights. For example, right to life. Right to life is a part of Universal Declaration of Human Rights. So, right to life as well as same part of Indian Constitution under Article 21. Equality is a part of Universal Declaration of Human Rights. Same equality is also part of our fundamental right, that is under Article 14. So, like that, there are many articles directly they are overlapping with our fundamental rights. Such type of rights are called enumerated fundamental rights. So, why we are categorizing like this? For example, if my equality right has been violated, it is fundamental right as well as it is human right. So then no need to separately you can approach the court that my human right has been violated. You can simply go to Supreme Court or High Court by of writ petition under Article 32 and 226 by saying that my fundamental right is violated, because those fundamental rights are part and parcel of human rights or ICCPR or ICSCR. So this is, that means those provisions are directly replicating in Indian Constitution. And next is unenumerated fundamental rights. There are many fundamental rights, there are many provisions of UDHR and ICCPR not part of fundamental rights of Indian Constitution, but however, they have been made as a fundamental right by way of Supreme Court judgments. For example, if you see the right to privacy, if it is in Karak Singh case, Supreme Court clearly said that right to privacy is not a fundamental right. But however, in Puttaswamy versus Union of India case, Supreme Court clearly held that right to privacy is a human right and it is a part and parcel of Article 21. That means this is a human right first, later it is not expressly mentioned in our Indian Constitution as a fundamental right. But however, the judiciary, by its proactiveness, they made this human right as a part of fundamental right in India. That's why we call such type of rights as unenumerated fundamental rights. And one more case that we have to discuss, that is Vishaka versus State of Rajasthan. So in this case, we all know that POSH Act, ultimately it came in 2013. But the thing is, in Vishaka versus State of Rajasthan, at that time, we don't have any penal provision which says that any sexual offense at the place of work, it is an offense. Of course, it can be punished under general criminal law, that is for sexual assault, rape, or any other provision. But still, a separate penal act is not there in India by saying that if you commit such type of offense at workplace, then it is an offense. So, however, the judges of Supreme Court of India, by taking inspiration from international conventions, as we said last time, CEDAW convention, that is elimination of discrimination against women. So by taking this convention and also discriminating the women, and women should have equality at workplace, by including all these international provisions, the Supreme Court clearly held that it is a part and parcel of human rights. So safety of women at workplace is a part and parcel of human rights. Then Supreme Court clearly held that it is a fundamental right, though even though it doesn't mention in our constitution, it is a human right, basic human right of women, safety. So that's why it is a part and parcel of fundamental right. So that means Supreme Court, by judicial activism or anything you call, Supreme Court in many cases clearly held that even though many human rights, they are not part of Indian Constitution, they made a part of fundamental rights by way saying that they are human rights initially. So that means even though all human rights which are in UDHR, ICCPR and Social and Economic Covenant are not part of Indian Constitution, but still they are made part of Indian Constitution by virtue of different judgments. So if you see this Aruna Shanbag versus Union of India case, so as you know that it is a case regarding euthanasia, as one of the victim, a nurse in a hospital, after attack by some colleague, sexual assault, etc. She spent 20 years in ICU. Then a case was filed by NGO asking to provide her euthanasia. Euthanasia means, as you know, that it is a mercy killing. So there are two types of euthanasia, that is passive euthanasia and active euthanasia. Active euthanasia means directly injecting a poison or any lethal substance into a body of the person who decide to be killed. That is called active euthanasia. That means you are giving some other substance, you are by way of either any chemical or shooting them some external substance, you are taking away their life. So that is called active euthanasia. But passive euthanasia means stopping the life-saving medicines. For example, if a person who is on a ventilator, if you off the ventilator, you are nothing, you are newly entering into their body, but you are taking away the support system. This is called passive euthanasia. So in this case, Supreme Court clearly held that right to die. Supreme Court in many cases it held that right to die is a fundamental right. Later it overruled and said right to die is not a fundamental right. But in this case, Supreme Court said that right to live with dignity is a human right. So it is also a part of fundamental right under Article 21. So this human right can be enforced by way of incorporating as a fundamental right. Next we have independent thought versus Union of India. So in this case, as many will know that if consensual sex with a wife who is below the age of 18, here in IPC they mentioned it is below the age of 15 or something, then Supreme Court held that it is against human rights, because a wife, maybe she is minor or a major, but we should consider as a minor only. This exception of age 15 cannot be granted under IPC, and Supreme Court clearly held that it is, apart from being a fundamental right, it is a human right, because women should be respected. Apart from that, women, she should have their own bodily freedom, etc. So held that human right is a part and parcel of fundamental rights. And there are many cases like this. IR Seolo versus State of Tamil Nadu. This is with regarding to the 9th schedule of Indian Constitution. So in this case also Supreme Court said that equality, right to life, all these, maybe these are fundamental rights, but these are part and parcel same sex between consenting adults. So this also Supreme Court decriminalized by saying that it is a human right, but maybe it is not a part of our fundamental right, but it is a human right that we should be respected, and it is a part and parcel of Article 14 and 21 of Indian Constitution. But one thing you have to remember, under Section 377, many will think that it has completely, struck down by Supreme Court of India. Even under BNS also, there is some gap with regarding this provision. 375 initially says with regarding to same sex and also bestiality. That means a forceful attempt of sex on animals. So this part has been excluded in BNS. Now there is a legal vacuum by saying there is no provision in Indian laws, like especially in BNS. If any person attempts any sexual assault in any animal, that is not part of our BNS. So there is a legal vacuum here. Coming back, so in this case, Supreme Court clearly held that the rights of LGBTQ, initially they are humans, later we can divide them based on their gender. So human rights, they are part and parcel of Article 14, 15 and 21, that is right to live with dignity. And role of pill. So the role of public interest litigation, like you see Bandhu Mukti Morcha case and even this Vishaka case. So in all these cases and MC Mehta case, so right to environment generally initially is not a part of fundamental right. However, Supreme Court in MC Mehta case clearly held that right to a free environment is initially a human right, even though it is not a part of fundamental right, but we can interpret under Article 21 of Indian constitution. So that means coming to enforceability of human rights, we can't say that violation of human rights we can directly go to court. But if that human right is part of your fundamental right, you can go to Supreme Court or High Court under Article 32 and 226. Apart from that, if any human right has been violated, if it is not a part of fundamental right, then also you can go to Supreme Court. If Supreme Court is convinced that, or High Court is convinced that, yes, this human right is a part of our fundamental right, then also they will enforce the human rights. So this is completely with regarding to enforceability of human rights in India. So by this I am concluding my lecture. Hope you enjoyed this session. Thank you.